So I want you to just put yourself in this specific situation for a second.
Okay.
You are a billionaire's grandchild, right? And you are sitting in this very intimidating mahogany paneled lawyer's office for the official reading of the will.
The classic movie setup.
Exactly, the whole movie setup. And you are expecting an empire. I mean, you are expecting a vast inheritance that reflects, decades of just staggering family wealth.
Right. Life-changing money.
Completely. So the lawyer clears his throat, he turns this heavy parchment page, and you discover that you are getting absolutely zero.
Oh, wow.
Nothing. You have been entirely, completely written out of the family legacy.
That's brutal.
It is, but wait, because as you're sitting there, just trying to process the sheer shock of that exclusion, the lawyer keeps reading.
Oh.
Yeah, and you find out that a small, fluffy Maltese dog is being handed a $12 million fortune.
I mean, it is just the ultimate record scratch moment in legal history.
Sure.
Because the sheer cognitive dissonance of discovering that, a 9-pound dog is suddenly a multi-millionaire while actual human descendants are left sitting in that office with nothing, it's just wild.
It really is. So welcome to the deep dive. We're just so incredibly glad you're joining us today.
Yeah, thanks for being here.
Because today, our mission is to really unpack the infamous legacy of Leona Helmsley.
The Queen of Mean.
Yes, the woman the public famously dubbed the Queen of Mean. We are going to analyze how a document that was, meant to seamlessly dictate the future of a vast billion-dollar empire, how it became literally the textbook example of exactly how not to write a will.
The absolute worst-case scenario.
Right. We're unraveling this wild intersection of immense wealth, public reputation, and honestly, the catastrophic danger of vague legal wording.
And what's fascinating here is that we aren't just looking at tabloid gossip about a rich lady and her pampered pet.
Right. It's bigger than that.
Oh, way bigger. This entire situation provides this really profound structural look at how a person's lifetime reputation can literally rewrite their legal intentions after they die.
Which is kind of terrifying if you think about it.
It is, because we culturally assume that a will is like this ironclad guarantee of our final wishes,
Yeah, you write it down, you sign it, it's law.
Exactly. We think of it as the ultimate legal shield.
Hmm.
But the Helmsley case proves that the ghost of your own public persona can completely dismantle those wishes the second they enter a courtroom.
Right, right. Because before we can even begin to understand the absurdity of this will and, the actual mechanics of a $12 million trust fund for a dog,
Wow.
we have to understand the immense scale of the person who actually wrote it.
For sure.
You don't just accidentally leave an 8-figure sum to a Maltese.
No, you certainly do not. That requires a very specific type of environment, a very specific type of insulation from reality, and quite frankly, just a staggering level of wealth.
Yeah.
Wealth that basically alters how you perceive consequences entirely.
So let's establish the foundation here, right? The Helmsley Empire. We are talking about Leona and her husband, Harry Helmsley.
Right.
By the 1980s, they hadn't just built a few successful businesses. They were the undisputed titans of New York City real estate.
Yeah, to put their footprint into perspective, they were just participating in the market. In many ways, they were the market.
That's a good way to put it.
I mean, we are talking about the Helmsley Palace, the Park Lane Hotel, the Empire State Building.
Wait, yeah, Empire State Building?
Yes. They managed or owned dozens of the most premier, recognizable properties scattered across the Manhattan skyline.
That is just incomprehensible wealth.
It really is. The scale of their real estate holdings was almost feudal in its scope. Like, they were essentially royalty.
And the money definitely reflects that, because by the time we hit the apex of their power, which is like the mid-1980s, their combined net worth is estimated at several $billion.
Billions.
Billions with a B. So Leona isn't just rich. She is famous.
Highly visible.
Right. Highly visible, glamorous, and in the business world, she really cultivates a reputation for being absolutely unapologetically ruthless.
Which is a critical psychological foundation for everything we are going to dissect today about her estate.
It's its real estate, right?
Yeah, in the cutthroat, hyper-competitive world of 1980s New York real estate, being ruthless is largely seen as a prerequisite for survival, let alone success.
Like it's a feature, not a bug.
Exactly. It's a feature. But Leona cultivated a persona that went far beyond standard corporate toughness.
How so?
Well, she didn't just negotiate hard. She famously belittled contractors.
Hmm.
She fired executives on absolute whims and micromanaged her properties with an iron fist. She really became a character.
A character that the public, frankly, loved to hate.
Oh, they ate it up.
It's that classic archetype of the imperious monarch just ruling over her domain. And that persona-like, the diamonds, the penthouses, combined with the extreme ruthlessness that ultimately laid the groundwork for her massive public downfall.
Because when you build your entire brand on being untouchable, on floating above the rules that govern everyday society, the public, the media, and eventually the government, they're always waiting for the moment you actually get touched.
They want to see you fall.
Right. They're waiting for the armor to crack.
Wow.
And for Leona Helmsley, that moment arrived with dramatic flair in 1989.
Ah, yes. The 1989 federal tax evasion trial. This is the massive turning point in her life.
Absolutely.
Because she gets taken down, but not for a catastrophic real estate deal or a market collapse. She gets taken down for evading federal taxes.
Right.
She and Harry were accused of billing millions of dollars in personal expenses, things like a silver clock, a mahogany card table, renovations to their personal mansion in Connecticut, billing all of that as business expenses to avoid taxes.
Just brazen stuff.
Totally. But here's the thing. What makes this trial so deeply ingrained in our cultural memory, it isn't the complex financial math of the fraud.
No, nobody remembers the math.
Right. It's the courtroom theater, specifically the testimony of her former housekeeper.
And this right here, this is where the infamous moniker, the Queen of Mean, is permanently, just irrevocably cemented into the public consciousness.
Because the housekeeper gets on the stand under oath and testifies that Leona Helmsley explicitly told her, quote, "We don't pay taxes. Only the little people pay taxes."
Just a devilly moonquote.
I mean, to be fair to the historical record, Leona vehemently and consistently denied ever saying those exact words.
Right. She fought that quote to her dying day.
She did. But here is the terrifying reality about public perception. It absolutely did not matter. The phrase stuck.
Like super glue.
Exactly. It stuck to her like super glue for the rest of her natural life. It became the headline on every single tabloid, the punchline on every late-night talk show, and basically the absolute core of her public identity.
And it had incredibly real, tangible consequences for her. That single phrase crystallized the jury's perception of her character.
Right.
She wasn't just a businesswoman who made, an aggressive accounting error. She was an elitist who viewed herself as fundamentally exempt from the social contract.
Wow. Yeah.
And so she was convicted. And at the age of 71, a billionaire hotel queen was sentenced to serve 18 months in federal prison.
I mean, let's just sit with that reality for a second. You own the Helmsley Palace. You are worth billions.
Billions.
And you end up in a federal penitentiary because you believed, or at least the jury believed, that your underlying philosophy was that you were above the fundamental rules of the game.
It is the ultimate hubris.
It is a phenomenal rise and a spectacularly public, humiliating fall.
For sure.
But wait, I have to push back here for a second.
Okay, go for it.
Because as wild as that 1989 conviction is, and, as fun as it is to recount the downfall of a billionaire like a cartoon villain, our mission today is to analyze her will.
Right.
And she doesn't die until 2007. That is nearly 2 decades after the trial.
Right, 18 years later.
18 years of water under the bridge. So my question is, should a person's past mistakes, like a tax conviction or a really nasty quote to a housekeeper in the 80s, actually matter when we are sitting in a probate court looking at how they want to give away their own private money?
That's a great question.
Like, legally speaking, it's her money, right?
Yeah.
The sanctity of private property dictates that she should be able to do whatever she wants with it completely, regardless of whether the public thinks she's a nice person.
It is an excellent pushback. And honestly, you are hitting on the exact philosophical friction at the heart of estate law.
Really?
Yeah, because legally speaking, you are entirely correct. A will is a private document. It is just a set of instructions for the disposition of personal property.
Right, it's just a contract with the future.
Exactly. In a purely theoretical, vacuum-sealed world of jurisprudence, the moral character of the person writing those instructions should not invalidate the instructions themselves. If you own a dollar, you decide where the dollar goes.
Simple as that.
But practically speaking, the legal system does not exist in a vacuum.
No, it does not.
The law is administered by human beings.
By juries and judges who, read the newspaper just like everyone else.
Exactly. When you have a massive, very public reputation for vindictiveness and a judicially established history of bad behavior like, say, a federal fraud conviction, That reputation acts as a heavy judicial lens.
Oh, I see.
Every subsequent action you take, especially an unconventional or controversial one, is viewed through that specific lens of suspicion.
Right.
Probate courts are technically courts of equity, meaning they are fundamentally designed to seek fairness. So when a judge is looking at a highly unusual document, they use the author's character to interpret their intent.
Okay, so she is wealthy beyond belief, she is deeply controversial, and she has this unshakable, legally documented reputation for being vindictive.
Correct.
Which brings us to the most surreal chapter of this entire saga, because Leona's notorious ruthlessness toward human beings stood in this incredibly stark, almost bizarre contrast to her extreme, unyielding affection for her dog.
Yes. And we really need to clarify here that we are not talking about casually tossing a few premium treats to a family pet or buying a nice orthopedic dog bed.
Okay, let's unpack this. We have to talk about Trouble. Trouble the Maltese.
Trouble.
By the time Leona passes away in 2007, she is a widow, she is increasingly isolated, and she is genuinely obsessed with this dog.
Obsessed is the right word.
Trouble wasn't just a pet who hung around the penthouse. Trouble was the center of her universe. Trouble ate meals prepared by hotel chefs, served on actual silver platters.
Which is an eccentric lifestyle, certainly. But her will absolutely sought to permanently institutionalize that lifestyle long after she was gone.
She has her attorneys draw up her final will and testament, and in it, she establishes an explicit formal trust fund, specifically designated for Trouble's care.
Right.
And the number attached to this trust, $12 million.
I really want the listener to just let that sink in for a second. $12 million.
It's insane.
Allocated for the ongoing maintenance of a single 9-pound dog.
And what blows my mind is the actual mechanics of this. Like, how does a dog even own $12 million?
Right.
I mean, dogs don't have bank accounts. They can't sign checks. How does this work?
Right, and this is where we have to look at the legal machinery of what's called a pet trust. You are correct. Property law dictates that animals are themselves considered property.
Okay.
And property cannot own other property. Historically, this meant you couldn't leave money directly to a pet. The courts would invalidate it under archaic rules like the rule against perpetuities because a dog can't serve as a legal measuring life.
Interesting.
But over the last few decades, almost every state, including New York, enacted specific statutes allowing for honorary trusts for pets.
So how does an honorary trust actually function on a day-to-day basis?
Basically, you appoint a human trustee. The money goes into a legal entity, the trust, and the trustee is legally bound by fiduciary duty to use those funds exclusively for the benefit of the animal according to the instructions you left behind.
Oh, I see.
So Trouble didn't have $12 million in her literal doggy bank. A human trustee controlled a $12 million fund with a strict legal mandate to spend it on Trouble.
And the trial transcripts detail exactly what this money was ostensibly earmarked for. It was for premium grooming, specialized dietary food cooked by chefs, and, incredibly, for security.
Security.
Yes, and that last one, security, sounds like a dark joke until you realize what happened the literal minute this will was filed in probate court and became public knowledge.
Yeah, the public reaction was absolutely visceral. It was a massive cultural nerve that got struck.
It was surreal. The dog began receiving actual, credible death threats.
Death threats for a Maltese.
Trouble the Maltese was getting death threats from anonymous members of the public. People were so profoundly enraged by the sheer inequality of it, this astronomical, life-changing sum of money going to an animal while human beings are struggling to pay rent, that Leona's estate literally had to hire professional armed private security for the dog.
It sounds like a subplot from a satirical movie.
Totally.
But it really highlights the extreme emotional reaction human beings have to the perceived misallocation of societal resources.
I mean, structurally, it's like Trouble became a canine head of state.
Yeah, basically.
I keep trying to picture the sheer logistics of a dog needing a tactical security detail. You have these burly men with earpieces and threat assessment training scanning the perimeter of a courtyard while a Maltese takes a nap on a velvet pillow.
It's quite the visual.
It is simultaneously the most absurd and the most deeply depressing image of wealth inequality I can think of.
But if we examine the psychology and the mechanics of wealth here, it's of a perfect case study. Immense wealth does something highly unique to human behavior. It allows for private, internal eccentricities to become external structural realities.
That's a great point.
If you or I love our dog an unreasonable amount, we might, buy them a slightly too expensive collar or let them sleep on the good furniture. our eccentricity is limited by our capital.
Right, I'm not hiring bodyguards.
Exactly. But if a billionaire loves their dog an unreasonable amount, they have the capital to legally bind the economy to provide millions of dollars for them.
Wow.
Now, setting up a pet trust, as we noted, is a standard legal procedure. Estate planners do it every single day for people who want to make sure their cats aren't sent to a shelter.
Sure.
The legal mechanism isn't the anomaly. The anomaly is the sheer disproportionate scale of the funding.
Because $12 million crosses a very specific line. It goes from making sure the dog is comfortable to something entirely different.
Precisely. When a number reaches that stratosphere, it ceases to be just about affection for an animal. It crosses over into a major legal vulnerability.
Because it's so much money.
Right. It looks inherently excessive. And in the eyes of the law, extreme excess invites intense judicial scrutiny. There is a concept in trust law known as the capricious purpose doctrine.
Capricious purpose.
Yeah. If a trust is established for a purpose that is utterly wasteful, absurd, or contrary to public policy, a court can step in and invalidate or modify it.
Oh, wow.
Leaving $1 million to polish a statue every day, for instance, might be struck down. $12 million for a dog flirts dangerously with that line of capriciousness.
Which is a perfect analogy. A vaguely written will with an absurd number attached is essentially a blank check handed to a hostile jury.
Oh, absolutely.
And leaving $12 million to a dog is definitely eccentric. But what transforms this situation from a bizarre piece of trivia into a catastrophic legal disaster is who was left out to make room for that dog.
Yes.
Because the millions given to trouble the Maltese were only half of the story happening in that mahogany lawyer's office.
The other half is the human collateral damage of that document.
Yeah.
The intentional exclusions.
Right, because in that very same will, Leona explicitly, by name, excluded 2 of her 4 grandchildren.
Our own grandchildren.
These were the children of her deceased son, Jay. She didn't just accidentally omit them or forget to update the document.
Yeah.
She actively, purposefully cut them out of the inheritance. She left millions to a dog, millions to her brother, millions to 2 other grandchildren, and 0 to these 2.
And we should establish a baseline rule of estate law here, just so everyone is on the same page. You absolutely, unconditionally have the legal right to disinherit your adult family members.
You do.
Yes, outside of a surviving spouse in most states, you do not owe your descendants a dime. You can leave it all to charity or a dog or whoever. But the way she executed this disinheritance is what created the explosion.
Because it is all about the exact phrasing her lawyers allowed into the document, right?
Right.
The court records highlight this specific fatal language. The will stated that these 2 grandchildren were cut out for reasons, quote, which are known to them, end quote.
Oh, reasons known to them. That is a phrase that haunts estate attorneys in their sleep.
Really?
Oh, yeah.
Because that is it. That is the entire totality of the explanation for disinheriting her own flesh and blood while handing an 8-figure fortune to a dog. And what makes it so legally egregious is the absolute lack of any supporting documentation to back up that phrase.
Nothing. There was nothing else.
There was no recorded family meeting prior to her death where she laid out her grievances. There was no contemporaneous explanatory letter placed in a safe. There was no verified context that a judge could look at and say, ah, yes, grandchild A stole from her, therefore this makes sense.
It was a complete structural informational void.
Just this vague, looming, passive-aggressive accusation dropped like a bomb in a highly public legal document the exact moment she died when she could no longer be questioned about it.
Yep.
But why? Like, why wouldn't a billionaire, someone who has literally the best, most expensive legal minds on the planet on retainer, just write down exactly what they did?
That is the big question.
If they slighted her, why not list the slights? Was this Leona executing a final vindictive power play from the grave, knowing it would drive them crazy with speculation? Or was this just a case of remarkably terrible legal advice from her attorneys who should have known better?
This raises an incredibly important question, and it is the exact reason law professors use this case in their curriculum.
Okay.
The answer is likely a messy combination of both. Leona was known for her hubris, and highly powerful clients often bully their attorneys into drafting documents exactly the way they want them, against the attorney's better judgment.
I'm paying you. Just write what I say.
Exactly. Just put it in there.
But regardless of whether it was her stubbornness or legal malpractice, the result was a massive, ticking legal landmine. Vague language in a testamentary document is the most dangerous element you can introduce into probate.
Because, to use the analogy again, it leaves a blank space on that check. It creates an evidentiary vacuum.
Precisely. When you write reasons known to them, you are legally asserting there is a secret rational reason for my action, but I'm refusing to provide it to the court.
Wow, yeah.
That immediately, instantaneously invites speculation. And let me tell you, where there is speculation surrounding $1 billion estate, there will inevitably, 100% of the time, be a lawsuit.
Oh, for sure. You are essentially begging the excluded parties to challenge the document because you have deliberately withheld the concrete reasoning a court needs to confidently uphold your decision.
You are leaving the courtroom doors wide open for the disinherited to walk in and tell their own version of the story.
Yeah.
If you don't supply the narrative, they get to supply it for you.
Exactly. Because Leona left the why completely open to interpretation, those two disinherited grandchildren were handed the perfect procedural opening.
It's like a gift.
It really was.
Yeah.
They didn't have to fight a well-documented list of their own failures. They just had to fight a ghost's vague insinuation.
And that brings us to the courtroom collision. The inevitable clash between what Leona intended on paper and the inescapable weight of her own reputation.
Right.
Because obviously, those two grandchildren sued the estate. They didn't just shake their heads and walk away from $1 billion empire.
Nobody does that.
Right. But their legal strategy, the actual mechanism of how they fought this, is what is so fascinating to me.
Because they couldn't just walk into probate court and say, we are her grandchildren. It is fundamentally unfair that a dog got $12 million and we got zero.
Even though everyone kind of feels that way.
Right. Morally, it feels unfair, but fairness is not a legal standard in probate. That argument would have been dismissed immediately.
So they needed a specific legal doctrine to invalidate the will.
Exactly.
And they used the doctrine of testamentary capacity and undue influence. Basically, they had to prove she wasn't of sound, rational mind when she signed the document.
That's the one.
But how do you prove an old billionaire wasn't thinking straight? You actively use her own documented history against her.
You use her reputation.
Yes. They pointed to the erratic, vindictive, unpredictable behavior that the public already knew about. They brought up the 1989 tax fraud conviction as evidence of her belief that she operated outside reality.
Right.
They brought up her public outbursts at employees. And crucially, they leaned heavily into the psychological profile established by their housekeeper's testimony decades earlier.
They painted a very specific, meticulously crafted portrait for the judge.
Yeah.
They framed Leona not as a rational, calculating matriarch carefully managing a complex estate.
No.
They framed her as an unstable, deeply vindictive, paranoid decision-maker who had lost her grip on logical reality.
They argued that the phrase, reasons known to them, was not a valid legal explanation pointing to a real event.
Right, it wasn't a secret reason.
Right. Rather, it was a symptom. It was an unexplained, vindictive punishment from a woman who had a massive historical track record of inflicting unexplained vindictive punishments on people. They weaponized the Queen of Mean persona to demonstrate a lack of rational testamentary capacity.
It is a brilliant, aggressive legal maneuver.
Mm-hmm.
They connected the past directly to the present. They used her public relations nightmare to solve their legal hurdle.
And here's where it gets really interesting. Just looking at the sheer timeline of causality.
Okay.
That famous quote, the claim that she said only the little people pay taxes, that happened back in the 1989 trial.
Yeah, a long time ago.
But that one phrase, that one singular moment of perceived extreme arrogance, essentially reached through the fabric of time. 18 years later, in 2007, that quote provides the character evidence that sabotages her own final will.
Because it provided the foundational architecture for her grandchildren's claim. It established a legally recognizable pattern of behavior.
Right.
The core legal reality here, the mechanism that every listener should understand, is that a will that appears purely vindictive, or a will that executes a massive disinheritance without explanation, rarely survives first contact with a probate courtroom.
But wait, earlier we said she had the legal right to be vindictive with her own money.
Yes.
So if she has the right to be vindictive, how does being vindictive invalidate the will? Isn't that contradictory?
It is a great nuance to explore. You have the right to be vindictive if you can prove you are making a rational, calculated choice to be vindictive.
Oh, I see.
If you write a letter saying, I am disinheriting my grandson because he didn't visit me in the hospital and I am angry about it, the court will uphold that. That is rational vindictiveness.
It's mean, but it's logical.
Exactly. But if you just strike out at people blindly, without stating a reason, while simultaneously giving $12 million to a dog, the court begins to view the vindictiveness not as a choice, but as a lack of mental capacity.
Wow.
If you are already perceived by the media, the public, and the judge as a fundamentally cruel person, an unexplained disinheritance just looks like uncontrollable cruelty. It doesn't look like a measured, rational, sound mind decision.
Right.
It looks like a continuation of the erratic behavior that sent you to federal prison. And that makes the document highly susceptible to being overturned.
So the grand plan, the meticulously drafted will by elite attorneys, completely backfires.
Completely.
We have a $12 million dog who requires armed bodyguards. We have angry grandchildren filing massive lawsuits claiming their grandmother was mentally unhinged. And we have a judge forced to wade into this unbelievable mess and sort out the collateral damage.
It's a total mess.
Which leads us to the ultimate question. What actually happened to the money? When the legal dust finally settled and the gavels came down, who actually got paid?
The unraveling of the will is where we see the actual practical mechanics of how courts handled these extreme, highly polarized situations. This is where theory meets reality.
So the judge steps in and takes a hard, critical look at the $12 million pet trust.
Yeah.
And the judge decides to slash it radically.
Yep.
The trust was reduced by a judge's order from $12 million all the way down to $2 million.
A massive cut.
Now, mechanically, how is a judge allowed to just cross out a number on a private will and write in a smaller one? What is the legal authority for that?
It relies on specific state statutes governing those honorary trusts for pets we discussed earlier.
Oh, right, the pet trust laws.
Exactly. Under the Uniform Trust Code, which heavily influences state laws, a court has the explicit statutory authority to reduce the amount of property transferred to a pet trust if it determines that the amount substantially exceeds what is required for the intended use. Okay. The judge essentially performs a math equation. They look at the dog's life expectancy, the cost of premium care, the cost of the security detail, and they determine the maximum reasonable amount.
And the judge's ruling was essentially that $2 million was more than sufficient for a dog's lifetime care.
I should think so.
Right. Even accounting for the luxury grooming, the private chefs, and yes, the 247 security detail, a 9-pound dog simply cannot organically spend $12 million. $2 million will easily get the job done.
Which, to be fair, is still an absolutely astronomical sum for an animal.
Oh, totally.
But it removed the element of pure capriciousness that made the trust vulnerable. But that leaves a massive mathematical problem for the court.
Right. What happened to the other $10 million? It didn't just evaporate.
No, the money has to go somewhere.
Right. So the remaining $10 million from that slashed pet trust was legally redirected. It was moved into Leona's overarching charitable foundation. This is often done through the Saudi press doctrine, or standard fallback provisions in the estate plan, where failed or excessive trusts are basically poured over into the estate's designated charities.
Exactly.
So a charity gets a massive $10 million sudden windfall simply because the dog's trust was deemed too financially extravagant.
Pretty lucky for the charity.
Right. But what about the human element? What about the 2 grandchildren who were cut out, the ones who sued? Did they get the rest of the empire?
Well, they didn't win their lawsuit in the sense of completely invalidating the will and taking over the estate.
Okay.
But they certainly didn't walk away empty-handed either.
Exactly. They ended up settling. The court records show that the 2 disinherited grandchildren settled with the estate for a combined $6 million.
$6 million.
Now, to be clear, in a multi-billion-dollar estate, $6 million is a tiny fraction.
Yeah, it's a rounding error to them.
Right. It is vastly less than they would have received in a standard equal inheritance distribution. But it is infinitely more than the $0 Leona explicitly mandated in her will.
It is the ultimate compromise.
Yeah.
And honestly, it is how almost all of these high-profile probate battles end.
The incredible irony here is just staggering to me.
How so?
When you zoom out and look at the final outcome, literally nobody got what that meticulously drafted legal document originally dictated.
Nobody.
The dog lost $10 million, the disinherited family members walked away with millions, and a charity got a $10 million bonus that was never specifically allocated to them in that original trust provision.
Yep.
The document, despite all the expensive lawyers who drafted it, meant absolutely nothing in its original form. It was torn apart and rewritten by the reality of the situation.
If we connect this to the bigger picture,
Yeah.
and this is the vital concept for the listener to understand, What you're seeing here is the absolute standard operational pattern in these inheritance gone wrong scenarios.
Really? This happens all the time.
Oh, all the time. We have a concept in law called dead hand control.
Dead hand control. I like that.
It's the attempt by a deceased person to control the behavior and capital of the living from beyond the grave. People view a will as a strict mandate, a final unbreakable law that the dead hand imposes on the living.
Right. That's what we're taught.
But the practical reality of the legal system is that once a will is successfully challenged in court, and there's enough ambiguity to sustain that challenge, the will ceases to be a mandate.
What does it become?
It becomes nothing more than the opening bid in a complex negotiation.
It's basically just a rough draft that the lawyers, the surviving family, and the judge end up editing together.
Precisely. The probate court steps in to mediate the intense friction between the deceased's written intent, the living family's legal rights, and the immense pressure of public policy.
Makes sense.
And usually, everyone agrees to settle, rewriting the will in the process, simply to avoid years of financially draining, emotionally exhausting litigation that would eat up the estate anyway.
Which means if you are listening to this and you want your actual literal wishes to be followed after you are gone, you have to write a document that is fundamentally bulletproof against these kinds of challenges.
You have to.
Which leads us perfectly into a discussion about the concrete takeaways for you, the listener. Taking a step back from the tabloid headlines, the queen of mean nicknames, and the absurd logistics of a tactical security detail for a Maltese dog.
Right.
What are the actual structural estate law lessons here? How do we avoid the Helmsley trap? We've touched on several mechanisms, but let's weave them together. How do you maintain that dead hand control successfully?
The overarching theme of all the lessons from this case is that you have to actively remove the ambiguity that breeds litigation.
Okay.
And the first way you do that is prioritizing specificity over vagueness. As we established, courts absolutely respect your right to leave money to your pets. They also fundamentally respect your right to exclude your human heirs. But the critical mechanical lesson is this. If you're going to execute a highly controversial move, like disinheriting your immediate family, you must provide a documented, specific, rational reason.
And you have to do that before you die.
Exactly. And you must generate that proof while you are alive and of sound mind.
You cannot just hide behind a passive-aggressive phrase like reasons known to them and expect the court to do your dirty work.
Exactly. Do not let a highly formal post-mortem legal document be the first place your family hears the bad news, or the first place a judge is introduced to your family dynamic.
That's just asking for trouble, no pun intended.
Right. If you want to cut someone out, you need to create a contemporaneous paper trail. Leave a separate letter of wishes with your attorney explaining exactly, factually, why you were making this decision.
Okay.
Have a recorded, medically verified family meeting. Prove to the future judge that you are of sound mind, that you fully understood the consequences of your actions, and that you had a rational, specific grievance. Without that specific architecture, you are just inviting a lawsuit based on your lack of capacity.
Okay, so lesson 1 is remove the blank space. Be aggressively specific and document everything while you are alive to prove your capacity.
Correct.
But what about the dog? What is the structural lesson regarding the $12 million? Because it seems like the money itself was the catalyst for the outrage.
The second integrated lesson is about maintaining proportionality to keep your estate out of the crosshairs.
Proportionality, right?
Extreme, highly unusual, or wildly disproportionate bequests act as giant, unavoidable magnets for legal challenges. A $12 million fund for a small dog is a fundamentally extreme bequest.
Yeah, there's no way around that.
It triggered the capricious purpose scrutiny. If Leona had set aside a modest, proportionally reasonable amount, say $200,000 or $300,000, which is still incredibly generous for a dog, it is highly, highly likely that no judge would have ever touched it.
Wow, really?
Yeah. And the grandchildren wouldn't have had the shocking headline they needed to garner sympathy. It would have flown completely under the radar.
It's the sheer size of the number that makes people want to fight it. It's the extravagance that gives the plaintiffs their ammunition.
Right. When you allocate wildly disproportionate resources to something eccentric, you give challengers the exact evidence they need to argue that you were disconnected from reality.
Oh, that's so,
that you weren't making rational decisions. You hand them the weapon they use to dismantle your will.
So we have specificity and we have proportionality.
Yes.
But what does this all mean for the final, arguably most impactful lesson we've discussed? Because this seems to be the one element that Leona couldn't buy her way out of.
The final lesson is perhaps the most profound, and it goes beyond strict legal mechanics. Your reputation is legally binding.
That's a scary thought.
It is.
Yeah.
We like to think of the law as blind, objective, and purely textual. But documents are ultimately read and judged by human beings who evaluate the character of the person who wrote them. If you spend your entire life cultivating a public reputation for being vindictive, erratic, and cruel, you cannot expect a judge or a jury to suddenly magically interpret your vague, controversial legal documents as generous, rational, or legally sound.
Yeah, that context matters.
Your past behavior is the inescapable context for your final wishes.
So to summarize the entire saga, the takeaway from the Helmsley estate isn't don't love your pets.
No, definitely not.
It is entirely fine, legally and morally, to love your dog and want them taken care of when you are gone.
Please do.
Right. The real takeaway is that you have to protect your intentions with clear, transparent communication and establish reasonable, proportional boundaries.
Exactly.
You can't just throw an 8-figure sum at a pet, vaguely insult your family in a highly public document, rely on a reputation built on cruelty, and expect the legal system to just rubber stamp it all smoothly.
You have to build a legal structure backed by a personal reputation that can actually withstand the intense scrutiny of a courtroom.
Which Leona Helmsley, despite all her billions and all her power, completely failed to do.
Yep, she failed.
And that is why her will was rewritten and why we are still studying her and her dog today. Thank you so much for joining us on this deep dive into the Helmsley estate. We hope you found the dissection of this wildly dysfunctional will and the legal mechanics of how wealth is actually transferred as fascinating as we did.
It's definitely an unforgettable one.
It is a crazy, tabloid-ready story, but the legal architecture underneath it is universally applicable to anyone who wants to leave a legacy.
Before we wrap up, I want to leave you with one lingering, slightly philosophical question to ponder on your own.
Okay, let's hear it.
We spend so much time and energy in our lives thinking about how to legally protect our wealth on paper. We hire expensive lawyers, we draft complex trusts, we obsess over the fine print of our assets. But if a meticulously drafted legal document, paid for by a billionaire, couldn't survive the crushing weight of our own personal reputation, how much of our actual lasting legacy is dictated not by what we write down when we die, but simply by how we treat the people around us while we're still alive?